We have an important decision involving the Second Amendment out of the United States Court of Appeals for the Sixth Circuit, arising from a situation in the state of Michigan. It's a crazy case, a lot of lessons here, not just for future judges handling Second Amendment cases, but for gun owners generally. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have breaking news here. We have a big decision out of the United States Court of Appeals for the Sixth Circuit, a case called Novick versus Federspiel. A crazy, crazy case involving our Second Amendment rights. According to the decision, which was 3-0, basically in favor of the Second Amendment, allowing a case under the Second Amendment and other claims to move forward against a local sheriff, two individuals sought to get their 14 firearms back that had previously been seized in the year of our Lord, ready? In the year of our Lord 2017. 14 firearms had been seized by a sheriff. And guess what? They still don't have their 14 guns back, apparently because the sheriff has taken the position that he doesn't believe or feels that the two individuals who are claiming these guns are theirs, that they are not able to demonstrate the guns belong to them, and therefore he is not going to turn them over. So let's talk about the facts of this case, and then I'll talk about the lessons from this case, including some of the Second Amendment specific items. But before we get to the facts, I just want to remind you of one thing, and this is why I'm doing this video. There's an old saying that I like to use with my students and others, and it goes like this. Dumb people do not learn from their own mistakes. Smart people learn from their own mistakes. And wise people learn from the mistakes that other people have made. So I'm going to try to make you a wiser person by understanding the facts of this case and how this arose, so you don't potentially make this same kind of error or get into the same sort of hot water. To begin with, the story starts in the year of our Lord 2017, where a sheriff seized 14 firearms in connection with an alleged domestic violence incident in a cabin in Merrill, Michigan. Now, it turns out that according to the opinion here, which I'll put a link to in the description of this video, the sheriff's department arrested an alleged perpetrator by the name of Benjamin Heinrich. Mr. Heinrich admitted apparently that he had aimed one of these guns at his child's mother, forcing her out of the house. This gave rise to a call to the sheriff's department, who showed up and took all the guns in the cabin. Well, as it turns out that the cabin did not belong to the perpetrator, Benjamin Heinrich, who ultimately pled guilty to some sort of deal and served a year of probation over this sort of event. But that's not what's relevant to this. What's relevant is that the cabin where this incident took place did not belong to Mr. Heinrich, but it belonged apparently to two family members, an uncle and a distant cousin by the name of Gerald Novick and Adam Wenzel. So Mr. Novick and Mr. Wenzel had 14 guns in this cabin that belonged to them. Maybe it was a hunting cabin. That's my guess. It's a cabin in Michigan. But the sheriff's office seized all 14 guns. Remember, we're in the year of our Lord 2025. These guns were seized in 2017 as part of an investigation, which lasted about a year. And then in January 2019, after Mr. Heinrich, who was the alleged perpetrator, was totally discharged and served a sentence, whatever you want to call it. He was done completely. That was January 2019. But the sheriff still refused to turn over the firearms to Mr. Novick and Mr. Wenzel, even though the person that committed the crime was Mr. Heinrich. So here you have two guys that lost 14 firearms in an incident that did not involve them. It involved a distant relative who happened to borrow a cabin in apparently the woods of Michigan. And despite a series of requests and a series of state lawsuits and federal lawsuits, guess what? they still don't have their guns back, and we're in 2025. Specifically, Mr. Novick and Mr. Wenzel sought to recover these firearms through 2 separate state law lawsuits and also the current federal case. So the first lesson here is, if you're going to let people into your home or into any location where you have firearms, make sure you know who they are and that they can be trusted not to do stupid stuff, because you may pay the price for being associated with these people. It's kind of like, don't lend people your car or your motorcycle if you don't trust them, because if they go out and get into an accident with your car or motorcycle, there's a good chance you're going to get dragged into the legal problem and perhaps even sued for being the owner of the car, among other things. So we want you to avoid the problem ahead of time. There's an old saying in litigation, which is always best to avoid the lawsuit rather than get into the middle of a lawsuit. So try to avoid the legal problem before it even can arise. So in light of these facts, let's turn to what happened with the Second Amendment in this case. The federal district court dismissed all the claims seeking to take possession of the guns by Mr. Novick and Mr. Wenzel, and basically ruled in favor of the sheriff. Now, this went up on appeal in a 3-judge panel in the U.S. Court of Appeals for the Sixth Circuit, which included on that panel Judge Kethledge, who was a shortlister for the U.S. Supreme Court several years ago for President Trump, but did not make it. He sat on this panel. This is a per curiam decision. So all 3 judges, Judge Mathis, Judge Larson, and Judge Kethledge, all agreed with this result. Now, when they turned to the Second Amendment claims, they rejected out of hand the theory or the argument advanced by the United States District Court dismissing the claims against the sheriff, and it was reversed. Specifically, this Sixth Circuit panel said that the Second Amendment claims against the sheriff can move forward against the sheriff in his official capacity, and that there could be a Second Amendment claim against the government for stealing or keeping possession of these firearms long after they're needed. Here is what the Sixth Circuit had to say about setting up the issue as to how keeping these guns could potentially violate the Second Amendment rights of Mr. Novick and Mr. Wenzel. Novick and Wenzel next challenged the grant of summary judgment to Federspiel, that's the sheriff, on their Second Amendment claims. The Second Amendment, applicable to the states through the 14th Amendment, provides that the right of the people to keep and bear arms shall not be infringed. The U.S. Supreme Court, in the Bruen case, clarified the analytical framework that applies to Second Amendment challenges. Under Bruen's 2-step approach, we must first determine whether the Second Amendment's plain text covers an individual's conduct. The Second Amendment's plain text protects the right to keep arms. The Supreme Court has said that this term protects a person's right to own guns for personal use, citing to Heller, and then it goes on to say, at issue here in this case is whether this right to own guns includes the right to possess, that is, to keep the guns that a person lawfully owns. So there you go. As we've talked about, the right to keep arms means the right to possess them. The right to bear arms means the right to carry them in public for self-defense. So here you have a situation where there were 14 firearms owned by these 2 individuals. The sheriff, i.e. the government, took the guns, and now they refuse to give the guns back to the alleged owners. And the owners have sued under the Second Amendment. And I'm happy to report that the U.S. Court of Appeals for the Sixth Circuit, in a very important case that will be deemed precedential and used by other courts. Remember the brick on brick and brick? Well, this will be one of those precedential bricks in favor of the Second Amendment. They will get used in future cases because the Sixth Circuit is a very reputable court when it comes to our right to keep and bear arms and all things for that matter. So what's going to happen here is that the Sixth Circuit said, you know what? This is a Second Amendment question, and we conclude that, yes, indeed, Mr. Wenzel and Mr. Novick have legitimate Second Amendment claims. Doesn't mean they're going to win the case at the end of the day, but they have legitimate Second Amendment claims. We're going to remand this case back down to see if they can prove to the federal district court or to a jury that they indeed own these firearms. And what's quite interesting is they point out the errors made by the district court in refusing to allow the Second Amendment case to move forward. Here's what the Sixth Circuit had to say on this point. The right to keep or bear firearms would mean little if an individual lacked any presumptive right to keep or bear his own firearms. In that event, one might ask, whose firearms would one get to keep or bear? The district court, down below, for its part, said the Second Amendment did not apply here because the sheriff's office had not interfered with Novik's or Wenzel's ability to buy or own guns. Wow. But that reasoning has neither any limiting principle nor any basis in the case law. To the contrary, it conflates Bruin's two steps into one. Now, this is important. This is important. You know, there's these arguments that we saw out in California just recently that got knocked down by the Ninth Circuit about you could only buy one gun a month, right? Here's an example where a federal district court judge had said, look, this sheriff can keep your 14 guns because you can go out there and go get other guns. And therefore, it is not a violation of the Second Amendment for the sheriff to keep these guns. Because again, you can have other guns. No, the Sixth Circuit just agreed with the Ninth Circuit in saying, no, that's not how it works. Just because you have guns now doesn't mean you cannot go get more or that you don't have the right to get more. It's kind of like we talked about on this channel before. I have a lot of books. Perhaps I have more books than I could ever read in a lifetime. But that doesn't mean I don't have a First Amendment right to go buy more books. Or if I want to go to church 10 times a day. Somebody might say, hey, you only need to go to church once a week or once a month or once a year at Christmas. Why are you going to church 10 times a day? It doesn't matter. I have a right to engage in the free exercise of my religion, for example. There's no limit as to how many times I get to do that. Just like there's no limit as to the number of times or ways I exercise my right to keep and bear arms. So if I want to have the 14 guns back from the sheriff and buy more guns, that's perfectly fine. But here you have a district court saying your right to keep and bear arms is not being infringed by virtue of the sheriff keeping these guns because you can get other guns. And the Sixth Circuit just nailed that and says, no can, no way, no can do, no how does this possibly fly as an argument. Don't say this again, district court. We're sending it back to you to get this case right. But what you just said here is totally wrong. Don't say it again, is what the Sixth Circuit just said in spanking this federal district court judge in this case. Moreover, if you think about what the Heller case said in 2008, we've talked also about this. In Heller, that case dealt with a law by the District of Columbia that says that you cannot own handguns. One of the arguments the District of Columbia advanced was, hey, you have no right to own a handgun in D.C. because you have the right to own long guns, shotguns, and rifles in D.C., and that's enough. And the U.S. Court of the United States Supreme Court says no. It is no argument against the Second Amendment claim to say that just because Mark has the right to have long guns means that the government can step in and prevent me from having handguns. By analogy, it's the same thing here. It is no argument for the government in this case, for the sheriff's office in this case, to say that because Mr. Novik and Mr. Wenzel already have the ability to go out and get new guns or have other guns, they have no Second Amendment right to the 14 guns that we took from them. Again, the Sixth Circuit just said that argument doesn't fly. And again, that's exactly the same logic that the U.S. Court of Appeals used in Heller that the Sixth Circuit just reaffirmed. Again, just because you have guns, just because you have opportunity to get other guns, just because you already have a bunch of guns, none of that is a basis for the government to be able to infringe upon your right to keep arms. That's not Mark Smith saying it. That's the U.S. Supreme Court saying it. And now it is, of course, the Sixth Circuit that just said this in this Novik case. So to wrap up, here's what the Sixth Circuit said the district court has to do when this case is remanded back down for further consideration to figure out whether Mr. Novik and Mr. Wenzel get their guns back. This is what the court said. The right to keep or bear one's own firearms is quintessentially conduct that falls within the text of the Second Amendment. The relevant questions here, rather, are twofold. First, whether these plaintiffs in fact own the guns, and second, if yes, whether the Sheriff's Department possession of them has been consistent with the nation's historical tradition of firearms regulation. The district court can now address these questions as necessary on remand. Therefore, we vacate the district court's grant of summary judgment to the Sheriff's Department on the official capacity Second Amendment claims. So while it's great news, of course, that Mr. Novak and Mr. Wenzel won this argument on the Sixth Circuit Court of Appeals level, it is really frustrating even to me to watch this, to see individuals who apparently own these guns There doesn't appear to be any evidence that they don't own these guns, and yet you have the government holding on to these guns from 2017 through 2025. Again, I think a big thing that is lacking in many instances when it comes to our government officials is a lack of judgment and a lack of discretion. And to me, just because you have an argument that might win in court doesn't mean you're doing the right thing. So again, I don't know the facts here. I don't know the backstory here. Maybe the sheriff's department here has really good reasons to think that these guns belong to someone else. But it does seem a little odd that these guns disappear from a cabin owned by these individuals, and now we're almost 8 years later, and they have not been returned to these individuals. And I assume that no one else has come and called in to look for these guns. So if you're the sheriff's department and you have these guns, you know they don't belong to you, because they're not the sheriff's department's guns. The question is, why would you not turn them over to someone with a legitimate claim? Why are you holding on to these? What exactly are you worried about? And what is the concern? And if there's another claimant out there asking for the guns, that's one thing. Then you let a court decide who owns them. But why is the sheriff's department holding on to these 14 guns when you have people who are swearing in affidavits they own the guns? Now, apparently the issue is that's just not enough proof from the perspective of the sheriff's department that they own the guns. But, a sworn statement is evidence in a court of law, and people go to prison and people are sentenced to death based upon sworn testimony in court. So yes, sworn testimony is indeed strong evidence of a fact. That's just how the game gets played. So anyway, we'll see what happens if this case continues and what goes on, and I don't know what's going to happen, and I don't know the details or the backstory, but it will be interesting to follow this as this case moves forward, and we'll see what happens. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxesdiner. Don't forget to subscribe both to YouTube and to Rumble. I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.